Hello everyone, I'm Anuj Jaggi and I'm a legal intern with Lexis and Company. And the topic for the second video presentation of the day is the International Commercial Arbitration, which is given under Section 2, Clause 1, Subclause F of the Arbitration and Conciliation Act. So the International Commercial Arbitration means an arbitration relating to disputes arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, and where at least one of the parties is the first requirement being an individual who is nationality or habituality of resident in any country other than India, or a body corporate which is incorporated in any country other than India, and the third one, a company or an association of body of individuals whose central management and control is in any other country which is not in India, and the government of a foreign country. The ICA taking place in India will be governed by Part 1 of the Act of 1996, and the award resulting from it will be a domestic award. The reason behind this is because of Section 2, Clause 2, it provides for that this shall apply, the section states that it shall apply where the place of arbitration is in India, and Section 2 Clause 7 provides for an arbitral award made under this part shall be considered domestic award. If these two sections are read together, then these provisions will explain the dynamics which are discussed below, as if an ICA if takes place outside the India, then the award would be a foreign award as defined in Section 44 and Section 53 of the Act. So what is international arbitration? And the answer behind this has been given under the Unilateral Model Law, Article 1, Clause 3. So the term commercial is explained in the Unilateral Model Law as the term commercial should be given a wide interpretation so as to cover matters arising from all the relationships of a commercial nature, whether contractual or not, and the relationships of a commercial nature include but not only they are limited to the following transactions, which are any trade transaction, distributional agreement, exchange of goods and services, etc. So the term commercial under the law in force in India, it was also given under the case of Athiya-Bari Tea Company Limited versus the State of Assam. Supreme Court on the construction of the expression trade and commerce held that in their trade and commerce wide sweep are included carriage of persons and goods by the road, rail, air, waterways, etc., and many more activities too numerous to be exhaustively enumerated, which may be called commercial intercourse. Through this decision was not only concerned with any provision of the Arbitration Act, it has been treated as a landmark case, laying down the broad parameters of the expression trade and commerce used in various legislations, including arbitration law. In the case of RM Investments versus Boeing Company, which was a case of 1994, the agreement was signed between the two parties for consultancy services from RMI to Boeing Company. The Supreme Court held that the consultancy services would fall under the relationship of commercial nature, and the expression commercial should be construed broadly, having regard to the manifold activities which are an integral part of the international trade. And Section 2 Clause 2 also states that this part shall apply where the place of arbitration is in India and only in India. So this was the topic of international arbitration, and I hope I was able to explain to you guys the concept behind it. So thank you.